22, and I would like to call to order a public hearing regarding a dangerous property condition at 2046 Second Avenue. Mr. Burning, may we have a roll call, please?
Yes, Mr. Burning?
Present.
Mr. Honolaw?
Present.
Ms. Davis?
Present.
All trustees are here.
Thank you. I would like to note that our Law Director, Laura Abrams, Township Administrator, Chris Gilbert, Director of Infrastructure and Development, Michael Gould, and Fire Chief Rob Leininger are also in attendance. I will note for the record that despite proper notices being sent, no one is here to represent the property owner in this hearing. Ms. Abrams, would you please recount the facts and procedural posture of this case?
Certainly. Before we start with that, I would just like the board to remind the board, under the new proceedings for the dangerous property, we provide a certified notice of the initial resolution determining it to be a dangerous property. Then the owner or the lien holders of record have an opportunity to request a hearing. As the board knows, in the past, we always just conducted a hearing. In this case, on 2nd Avenue, the property owner did request a hearing, and so the hearing was scheduled. The property owner did ask for a continuance initially to get an attorney, wanted 30 days. I indicated to him that the statute requires the hearing to be held within 7 to 15 days unless it's mutually agreed otherwise, and I indicated that the township wasn't willing to continue this hearing based on the condition of the property and the fact that this is the second time that we've declared it dangerous. This is the second round of hearings this person has had. So what I indicated to him, and I'll just state this for the record, is that if he got an attorney or contacted an attorney, he should have the attorney contact me, and then we would talk about scheduling. At that point, he had requested that, I believe it was his construction company represent him, and the construction company individual contacted me and said he couldn't come because he had taking his kid back to college or dealing with college, and I indicated that, again, we weren't willing to continue the hearing, but that he should contact me if they got an attorney to discuss it. I have not heard anything back since that conversation, but they were certainly well aware of the date and time. We did follow up with not only the emails, but certified mailings to both the property owner and the construction manager, as well as advertising it in the, I believe, Cincinnati Enquirer, as well as posting it on the property. So they were aware of the hearing date, but I wanted the board to know that there was a request for a continuance, which was denied because the statute doesn't require it, and they did not obtain an attorney. So if they had asked, if they obtained an attorney or had just, I said just even call them, and we'll talk to them. But as we know, this is a property that's been a problem since April of last year. We did give the owner time to fix the property, and as you'll hear, nothing has been done since then. So that's just the beginning of it. I think what we'll do, since a hearing was requested, I think we should really have a hearing. If they come at any point during the hearing, certainly they'd be afforded an opportunity to present their evidence, but we'll just conduct ourselves, if the board doesn't mind, as a hearing on our part. So with that, I'd like to have Robert Leininger provide information to the court. Since it's a hearing, if you wouldn't mind, Ms. Davis swearing him in.
Chief, do you solemnly swear the testimony you're about to give before this body is the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Thank you. All right, Chief, if you had an opportunity to view the property at 2046 Second Avenue? Is that the right address?
Yes.
Yes, thank you. All right. Well, let's go back. When's the first time that you dealt with this property?
You refer to my notes.
Please do.
Way back, 2021. Actually, June 25th, approximately 2021.
Okay.
It was the first time that this was brought to our attention.
I think it was before that.
Pardon?
I think it was before that. Do your notes have? I think that's the second time we were looking at it, because we have the initial declaration of dangerous property was April 13th of 21.
Okay.
Do you have that?
do not have my report in front of me for that date.
All right. What's the first date you have? You have in June?
Well, there's correspondence that I have here in June of '21,
Okay.
but I am very familiar with the property over the last, or in 2021, early part of 2021.
All right.
It was brought to our attention that that property was in poor condition, and it was a concern of safety for the community,
All right.
and I was asked to evaluate it at that time.
All right, I do have a report from you on March 3rd of '21. Do you want to just, here, I'll just have you look at it.
Yes, ma'am. Thank you.
I think that's the first time we had you look at that in an official capacity.
Yes, actually, I was also joined by Captain Mike Stein. We visited the property on March the 2nd, 2020.
Oh, was that the first time?
Yes.
All right, at that time, what did your report indicate that you saw?
I found the property to be in extremely poor condition. The structural integrity of the building was in question. I was shocked to find that approximately 1/3 of the building had been removed, exposing the structural members of the building, including the trusses, the floor joists, and the structural members of the exterior frame. It looked actually as though it could just fall over at any time. There was concern whether or not it was properly shored to accommodate any shift in weight or shift in if the wind would blow a certain way, that we were concerned that maybe the building would in fact collapse. And then through other visits, we did observe that the property owner did attempt to try and stabilize that building with putting in some shoring and some various structural members to try and minimize the chance of collapse.
Okay. But you weren't satisfied with those, were you?
No, I was not.
At that point, did we take official action?
We did. At that point, it was brought to the board's attention, actually to Mr. Gilbert's attention, and then a process was then started to facilitate a dangerous property hearing.
And that ultimately involved a declaration, as I stated earlier, on April 13th of '21. It was Resolution 26/2021, declaring it a dangerous property. Is that
That's correct.
accurate? And then we amended that under the old process in 41/2021. Is that correct?
That's correct.
Do you recall why we didn't demolish the property at the time?
We had met with the contractor, Mike Gould and I had met with the contractor who, in good faith, was trying to make an effort to fulfill his obligation to actually try and mitigate some of the structural deficiencies. He had brought in an engineer and actually showed us drawings and everything of what his proposed plan was. And at that point, we felt like, again, kind of in good faith, he was going to make the efforts to then complete the repairs that he had shared with us.
Do you know if they got a repair permit for that?
Yes, it was. He did get the permit.
But that's expired at this point, isn't it?
That is correct.
All right, when's the last time you went to view this property, most recent?
The most recent was yesterday. That's August the 8th. Yes. That is August the 8th at approximately 3:15 p.m. I visited the site.
And did you observe any difference in the property from your prior visit?
No.
Well, there's one, isn't there? There's a fence.
Well, actually, the fence was there because my last visit was June the 13th.
Okay. From before, I mean, the initial declaration, they didn't have a fence.
Correct.
Okay. So the board did require them to put a fence up, did it not?
Correct.
And they did put a
one,
fence up, okay.
yes, but it was not locked.
Okay, it's not secure at this point? Okay. What does the actual structure look like at this point?
I have photos taken of January the 13th and,
June the 13th.
I'm sorry, June the 13th, 2022, and I'd be glad to share
Yeah.
that with you. And the pictures are basically the same.
So these are the ones the board would have seen before its prior resolution, but we'll send them back. Are they accurate as to what it looks like today?
Yes, that is correct. And I do have 2 electronic photos that were taken yesterday to document my inspection of the property, but I was unable to duplicate them for today.
So is there anything about the structure that has been worked on since you went out there in June?
My biggest concern is that there is no work being done. There's really they haven't tried to demolish it, tried to improve any of the structural defects, and even to clean up the property, it's in disarray. I would consider it a nuisance property because the grass is high. I mean, there's obvious signs of neglect just by a layperson walking by and observing that property. They would say that it is neglected.
You saw no evidence of any repairs?
No.
No one was working on the property when you went out at any time?
No.
Have you ever seen anyone working on the property?
Not in the past year.
The windows?
Are they new?
Yeah, I was looking at whether there were new windows. Did they put the Tyvek on? Is that at some point? It's like, it's not actual Tyvek, but some sort of,
So if I may approach here with
Yeah.
some additional photos. So this is actually March 18th.
Oh, okay. So it's your thought that if they did any repairs or remediation, it would have happened closer to when we did our initial resolution in April?
Yes.
Because we're now well past a year and they've done nothing. All right. Based on the condition of the property today, do you still feel that it's dangerous, structurally defective, insecure, and unsafe?
I do.
Is it your recommendation that this property be demolished at this point?
Yes, it is.
Have we received any indication from the Hamilton County Building Department as to their view on this property? Are you aware?
I'm not aware that it did not come to my desk. If there was any other correspondence, it may have been circulated through the Code Enforcement Division.
I'm going to go ahead and give you, I apologize, I didn't forward this to you earlier. Code Enforcement Division is through the fire department, so you can speak on its behalf.
Okay.
What's the date of that document?
August the 3rd, 2022.
Okay. And who's it from?
It is from the official, let's see here, Hamilton County Planning and Development.
What is there, does it relate to this property at 2046 Second Avenue?
Yes, that is correct. That's the address on the top.
All right, and what does the building inspector find with regard to this property?
So the unsafe building conditions observed says the building is open to the weather, deteriorated, and unsounded. On several occasions including April the 6th, 2022, an inspector with this department inspected the premises and posted a field order as unsafe building. At the building department's request, the owner secured a repair permit in July of 2021. No inspections were requested, and the permit has expired. The building is hereby declared insecure, unsafe, and structurally defective.
Thank you very much.
Yes, ma'am.
All right, is there anything else you'd like to state with regard to this property?
Well, back to my original statement of extending kind of a good faith effort to try and allow the owner opportunities to mitigate the hazards and actually complete the plan that was originally submitted. He has failed to do so. And we have extended all professional courtesies, including the time of our staff, to interact with this gentleman, as well as numerous hours dealing with the building department, assisting with trying to help him acquire the proper permits. Mike has spent hours trying to coach him through the process. So we have really been over backwards to try and salvage this piece of equipment. And the intent originally was to see that it was remodeled and rehabbed back to a useful property. But unfortunately, due to the uncooperative nature of the owner, none of that plan came to fruition. So therefore, I recommend that the property be condemned and demolished.
All right, thank you very much. That's all I have unless the board has any questions of.
The only
Chief Ryan.
thing, and I might have missed this, Chief, but did we ever receive any report from a licensed structural engineer on the property? Do you know?
I don't recall. I don't have
I
that.
think we did. I'll have Mike Gould testify.
Okay, okay.
He dealt with
that's
that.
fine.
Yeah, if that went through, it may have been, Mike may have dealt with that. I don't have that in my file.
Okay, thank you.
All right, well, let's have Mike Gould testify.
Would you raise your hand? Do you solemnly swear the content of your testimony to this board will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, to answer that question, was there ever a structural engineer report provided?
Yes, the property owner did come up with a structural engineer report. That was the way in which he utilized in order to get his building permit to do the repairs and the improvements that he promised us over a year ago. I have not seen anything, and to my knowledge, he has not acquired anything recently. And as you're aware of, the building, the structure has continued to deteriorate at a rapid rate because of the fact that it's so exposed to the elements.
Let me ask you, does it still have like the whole corner is still open? Is that?
That is correct, yes.
Yeah.
Compromising the entire structure.
Can I ask a question?
Mhm.
Just to interject, I think it's important to note for the record that there's nothing in the statute that requires the township to obtain a structural engineer report to declare a property dangerous pursuant to the code either. So while the property owner may have received one in order to allow him or enable him to obtain a building permit, it isn't something necessarily that we do on a customary basis to determine a property to be dangerous. It isn't something that's required by statute or something we do in any previous case either. So I don't want to give the perception that it's something that we do routinely or that it is something that's required.
No, and this,
No, and I didn't mean that.
No, I know you didn't mean that,
Yeah.
Mr. Earnlaw, but I just wanted to make sure in the record that we clarified
And
that.
beyond that, I mean, anybody that looks at the pictures of this property can see it's a dangerous property. It's not like there's somebody that can look at this and say, well, that's not a danger to the neighborhood. It's also an eyesore to the neighborhood. And
well, I would
it's been
just,
over a year.
right, and I would just clarify that the structural engineer, when the board took this up as a dangerous property previously, and we declared it dangerous, as is the board's tendency, is to help work with property owners. We had the building department at that time said it wasn't structurally sound. I mean, they issued the same order that you heard issued this evening. So we get to rely on the Hamilton County Building Department and their determination, and that's what we relied on. His argument was that he believed he could make it safe, and that's why we required the fencing and said, look, we're just not going to take your word on it. You need to get a structural engineer. So he did. So that was the impetus for the board allowing him time to repair it. That's why we didn't demolish it at that point. As Mr. Gilbert says, this is not a requirement. We are entitled to rely on the building department. And both then and now, they found it to be structurally defective. So just because we don't take demolishing someone's property lightly with this board, we were willing to let him try to work on it. He had a contractor that he presented at the hearing, as the board knows. We said, look, if you get a structural engineer to say it's possible, because we didn't believe it was possible to repair it. He found somebody who was willing to say it was possible. So we went with the possibility. That was over a year. It does, as was testified, it's worse now. It's more structurally defective, and the building department believes it to be defective. I mean, they have the same language we have, structurally defective, insecure, and unsafe. So they're going with the same rule of law and the same tests that we have to apply by, and they found it to be that way.
So the building department issued a permit, is that correct? They issued a permit?
Yeah,
but
to
the permit
repair.
is now
It's expired. So even, one of the things they said to me in an email was they want to keep working on it. Well, they can't work on it. And there's no keeping working on it. There's no work being done. They did put the fence up, but it is not even a secure fence. So it's never had any actual work done on it. And we, as the board's well aware, we already declared this dangerous because it was dangerous. We just basically stayed the demolition order to try to help the property owner, and he's done nothing, so.
And just to further illustrate to the lengths we've gone to, I did have conversations with structural engineers last week. They reviewed the report from the building department and reiterated that we'd be wasting our resources to spend time and money and having them come out and evaluate the structure. They never go against the building department's recommendation. So what the building department provided trumps everything.
Since you're testifying, do you have any concerns about a deck? I mean, do you believe it's also structurally defective?
Yes,
You've been out to this property several times, have you not?
that is correct.
Have you ever seen any work being done?
No.
All right, that's all I have. All right, and I will note that the owner or representative is not here. The board has seen the pictures previously. The board is well aware of this property. Under the new process we follow, you would make a finding here, and then we pass the resolution confirming it in the regular meeting of the trustees, but you would do a finding here.
So as there is no other information to be presented, the board will now deliberate.
Well, I would let the record reflect that now it's about 5 minutes till 5, and as Laura stated, the property owner is not here, and it's obvious from the testimony, it's obvious from the pictures, that there's no effort being made to try to bring to get this property out of the dangerous condition in which it currently is. I think it's time for this board to act. We have a duty, and when we have a property such as this, we need to move forward. Based on that, I would make a motion that we find this to be a dangerous property, and that we take the necessary steps for its demolition.
And I went over there last Friday to see for myself if any work's been done since last year, and there has not been, and anybody that sees that property can tell it's a dangerous. So, Joe, I would second your motion.
And I would just follow up, because I have a couple comments. I would just follow up with what my colleagues said individually, but collectively, we have a duty to demolish these dangerous properties, but we also have a duty to the community. And I know that there are no residents here, members of the community here tonight, but if anyone takes a look at these pictures and see the condition of this home, no one will want that piece of property next to their home. And we have a duty to our residents to make sure that, children are safe, adults are safe, and nothing nefarious goes on inside of these abandoned properties. So, like I mentioned, we have our duty to demolish these nuisance and dangerous properties, but we also have a duty to our residents to provide a safe community. So.
All right, roll call. Mr. Burning?
Aye.
Mr. Honalaw?
Aye.
Ms. Davis?
Aye.
Motion carries.
Okay. So we're making an immediate removal motion?
Yeah, we'll do it in the resolution does it, so the resolution will formalize what you did here.
Nice.
Yeah.
Dated sufficient for,
Yes,
Need to
for
close this
demolition,
meeting?
yes.
So do I have a motion to close?
Nope, not yet.
Nope.
Well, it depends, if you want to do this as the same hearing, why don't you close, you're right, why don't we close this hearing and then move on?
So do I have a motion to close the hearing reference 2046 Second Avenue?
So moved.
seconded.
All those in favor?
Aye.
Meeting's closed.